But thank you all so much for joining us this evening. I'm Erin May Quade. I use she, her pronouns. I'm the senior advisor at Gender Justice, and I'm joined by two incredible panelists tonight. We are going to talk about the impact on protections against conversion therapy in Minnesota and North Dakota in light of the Supreme Court's decision yesterday. Jess, I'm going to come to you first. Please introduce yourself. Tell everyone why you're wonderful.
Hi, I'm Jess Braverman. I'm the legal director at Gender Justice. You probably know who Gender Justice is because I think this is our webinar. But we litigate a lot. As a legal director, I litigate a lot of civil rights cases involving, among other things, LGBTQ rights.
Amazing. And also joining us this evening is the wonderful, the esteemed, my other esteemed colleague, I should say, Senator Scott Dibble. Senator Dibble, please introduce yourself for the Zoom room.
Thank you, Erin. Yes, I'm State Senator Scott Dibble, one of the many members of the Queer Caucus in the state legislature. We're four in the Senate and like 15 in the or 12 to 15 in the House. There's a number of us. Used to be just me and Erin and a few others, but a lot of queer legislators. But I'm the one that is of tenure of council, been around a while. So and was the chief author of the conversion therapy bill ban back a few years ago when we passed that.
And advocated for many, many years and did a beautiful job passing it. So we're going to talk about all of that tonight. As we talk about tonight, so Gender Justice works to advance gender equity through the law. We work in Minnesota and North Dakota. And so the United States Supreme Court decision and Chiles v. Salazar, it came down yesterday. And I think that there's definitely some nuance that we want to impart. We do legal expert analysis in addition to court cases, and that's why I'm so excited to have the chief author of Minnesota's conversion therapy ban, as well as our legal director, to really talk about this. And so before we get to the case, Senator Dibble, I just want to come to you really quickly. If you could just give us a colloquial, definition of what conversion therapy is or how you would describe it.
Well, I like that you use the word therapy and air quotes with your fingers because it's not actually a valid or legitimate form of therapy. It's been credited by every major health professional organization that you can think of. It is a treatment modality. Some colloquially call it torture. It is purports to be able to mostly through talk therapy. There may be some other coercive techniques that those are kind of the product of a bygone era to persuade someone that they can change their sexual orientation or their gender identity. That is proven to not be so. These are immutable traits, if you will, and it only causes great harm to the individual who's being so-called treated. Harm of all sorts that you can possibly imagine. And in fact, the modern standard of practice is to help people gain a better understanding and appreciation of who they are and how to be comfortable and move through the world and aspire to live a good and healthy life in appreciation of the fullness of who they are and how they were born.
Thank you for that. And I've always likened it to like if I went to therapy to be like, don't have curly hair. Well, sorry, I do. That's just it, period. So 27 states and then Puerto Rico and DC have banned or limited conversion therapy in some way. In North Dakota, it is a violation of state ethics regulations for social workers to engage in conversion therapy. And then Minnesota banned conversion therapy for minors and vulnerable adults in 2023. With Senator Scott Dibble leading the way. So, Jess, I want to come back to this case. Talk to us a little bit about the history of this case before the Supreme Court. What question was the Supreme Court answering? Talk to us a little bit about that.
So Colorado passed a conversion therapy ban similar to Minnesota's. And there was a therapist in Colorado who I believe, she was a licensed therapist, but she does provide like religious oriented therapy. And I make that distinction because a lot of the bans apply to licensed therapists. So if you're just a clergy member who's not a licensed therapist, the bans may not apply to begin with. But this person is a licensed therapist and wanted to engage in like conversion therapy, which she deemed talk therapy, meaning they they she doesn't want to provide like electric shock therapy or other forms of what's called aversion therapy, which are like physical interventions. It is just about the communicate, it's like I don't want to just call it, it's not just a conversation, right? Because anyone who's been to therapy knows people use treatment modalities, they use tools. It's not just a conversation, right? It's with a therapist, but what they're calling talk therapy. So just the talk component of it. Um, she said this law is unconstitutional as applied to me, meaning like, I'm a provider. I want to engage in talk therapy with my clients, conversion therapy, so called, and this law prohibits me from doing that. And so she asked for what's called a preliminary injunction, meaning she asked the court to put a pause on the law, like say, for now the law doesn't apply to you, while she litigates her case. That request for a pause went up to the US Supreme Court, and that was the issue in front of them was, is this therapist likely to win her case? Where she's just claiming the talk therapy component of this bill is unconstitutional. So that's kind of the backdrop of the case.
And that's, I think, really important for folks to know because a lot of times, and we see this happen when the Supreme Court decides a case, it gets flattened, the legal issue at hand kind of gets muddied. But really, what was in front of the court here was, is this preliminary injunction against the Colorado law going to go into effect for this one therapist? So that was the question that they were answering.
Yeah, like the easy way to kind of explain what's going on is like a therapist said, hey, the talk therapy component of this law is unconstitutional, and the court was deciding whether to strike it down. With the law, there's more nuance, so I wanted to give the more nuanced version. But for anyone who um, has an aversion to legalese and lawyers speaking, like that's a more simple, the more simple, like unnuanced ways to say like she challenged this law, saying it's unconstitutional, it violates my free speech rights, basically.
And so, what did the court say? What was the answer that the court gave us in this decision yesterday?
So the court had to determine whether the law was likely to violate the therapist's free speech rights. She was arguing this is a content specific restriction, meaning like if I were a therapist who wanted to affirm transgender clients, I would be allowed to do that. But if I'm a therapist who, a transgender client comes to me and says, I don't want to be transgender, all of a sudden I can't talk to them. And yeah, and I'm not talking about conversion. Like this is her legal claim. It's not my take on conversion therapy. And what the court said was, this is not what's called a content neutral restriction, meaning it prohibits therapists from doing conversion therapy, but it allows therapists to affirm someone's gender identity, to affirm their sexuality. And because it's not neutral, what the court basically says is that's a problem. And so there's this sub question of like, well, what if the lawmakers are regulating a profession, right? Like as a profession, I'm a licensed lawyer. There's all sorts of ethics obligations I have to follow that restrict my speech, right? Like, for example, I cannot say out loud anything confidential about my clients on this Zoom call. I can't. Does that restrict my speech? Yes. But at the same time, like there's a reason that law is in place, right? Is to protect the clients. I'm a licensed lawyer. If I want to keep my license, I can't share that confidential information. So there's all kinds of speech-based regulations that governments put on licensed professionals. And so the question then is like, okay, like fine, this obviously impacts her speech, but she's a licensed therapist. Like, why can't you say like this treatment's been discredited? It's a treatment, not just a speech. And the court said we're not going to make that distinction. We're going to say like this is a speech restriction, and we're going to find that it does, there's First Amendment problems here where you can't just say this is a regulatory thing. This therapist has the same First Amendment protections as anyone else. So like if I were talking to Erin and I said it's wrong that you're gay, like like she has the same protections even if she's doing that as a licensed therapist in the course of her treatment. And I find that odd, but that is basically the direction the ruling went.
Which I'm like, are the bunch of lawyers going to sue and say like attorney-client privilege is a violation of your First Amendment rights? Um, so I guess my question for you then is based on this court decision, what does that mean for us? And I want to start actually in North Dakota and social workers. So North Dakota Board of Social Work Examiners, they made it an ethics violation for social workers to engage in conversion therapy. And maybe the bigger question is, did the Supreme Court decision strike down everybody's conversion therapy bans? There's municipal bans, there's ethics rules, there's, statewide bans. Did that happen all of a sudden yesterday?
No, no, that didn't happen. It's more like the court is basically saying like if with this current makeup of the court, if you come to us challenging one of these bans, the talk therapy component of these bans, you're probably going to win, right? Like that's kind of the upshot of the ruling. This ruling isn't like, it's just is Colorado's law unconstitutional as applied, or not even that. It's like, is Colorado's law likely unconstitutional as applied to the specific therapist? But it's really hard to read the opinion and say that the court would come out any differently if someone challenged Minnesota's law or if someone challenged the social work regulations in North Dakota. So, as a technical matter, no, it didn't even strike down Colorado's law as a technical matter. But like the upshot of the ruling when you read it is it's pretty clear what the court's saying, which is like we're not going to allow these restrictions on the talk therapy component and therapy in quotes, of course, of conversion, quote unquote, therapy.
Scott, I want to bring you into the conversation and just talk a little bit about, first, I would love to talk to you about chief authoring this bill, and maybe how it came to you. And if you know, like, how close is our law in Minnesota to Colorado's?
Thanks. I'll answer that question first. I immediately went to look at the language of Colorado's law and did a side-by-side comparison with Minnesota's law, hoping that because there had been some speculation out on the interwebs that our law didn't have some of the aspects and components that the Colorado law did, and so perhaps the holding of the courts wouldn't apply. Unfortunately, I discovered that our Minnesota law is almost identical. So the flaw, if you will, the free speech flaw that was found in the Colorado law, not being position or content neutral, they would find the same if the Minnesota law was specifically challenged as well. So then, of course, that starts us down the path of thinking about, what next. But first, I'll just talk a little bit about, passing the law. The law came about as a function of, many, many, many years of people stepping forward very bravely, saying, I was subjected to conversion therapy. It was of great damage to me and my life and my ability to grow up healthy, happy, secure, safe, sound, and it had all of these lingering consequences for me. And young people should not be subjected to the same thing. It reminded me a lot of a law that we passed a number of years prior around tanning beds, where it is a matter of law that anyone under 18 years old cannot get into a tanning bed. It's very dangerous, causes skin cancer. A parent can't sign a waiver. There's what they call a compelling interest of the state to keep young people safe from the consequences and harm of tanning beds. I don't mean to trivialize what conversion therapy is or what it means, but it's similar in construction in that there is no parent who can say it's okay to subject a child to conversion therapy because I'm the parent, I'm the minister, I'm the responsible adult, etc. Because it's shown to be very, very consequential and very damaging. And it was a grassroots movement that was built by people stepping forward and saying, we want and expect something different from our leaders in our state. And, it's your job to keep young people safe. And it took a long, long time just to build the case and to persuade my colleagues, even Democratic colleagues, that this is something we could do. It then became a large national movement. We were kind of eventually, I mean, I think we were at the forefront of having this discussion and proposing policy remedies. But then there was a lot of momentum that really picked up steam across the country, and we were a part of that big sweep of states that banned conversion therapy. And we went through a tremendous amount of legislative process and debate, et cetera. But a very, very broad coalition was built in the end with people and professions from all walks of life. It was really pretty astounding.
And there were a number of municipalities that all over the state of Minnesota that also passed municipal bans as well before the state even got there. And I think, that just shows the cross, state geography, and really cross party lines. This wasn't a partisan vote when we voted on it in the Senate, and it wasn't partisan in the House either. And so, I think generally it was like, yeah, we shouldn't torture kids. And that seemed like a good thing to say. And so maybe, I would love to just talk to you a little bit about how you're feeling today, how you were feeling yesterday, and maybe what your thoughts are on where we go from here.
So I've been a part of the queer movement, the LGBTQ movement for equality and freedom for many, many, many years. So part of me is feeling like here we are, here we go. We are tough, we are resilient. This is just another setback in centuries of setbacks. I've been around for centuries, but I've been around for several decades. And, I'm very, very accustomed to the promise of our country, the freedoms that we would expect, the ability to enjoy the protections of our laws. It's always one step forward, two steps back, two steps forward, one step back. The fact that two of the most progressive members of the Supreme Court uh, uh, joined the conservative Christian nationalist majority just is an indication of the kind of double standard under which we live. That the reality of our lives and what we experience, and the devastating consequence of what amounts to an intellectual exercise for someone that doesn't translate to an actual, on the ground consequence for young people and their ability to thrive and succeed and even survive. But I'm also just absolutely devastated, because while I know that we will overcome this, we will prevail ultimately, it may take, I think we'll find some novel policy remedies, but ultimately we'll prevail in the central question as well, and that may take decades, and the consequence to people's lives will accrue and accumulate. Um, but like I said, immediately shifted back to we got to get to work, we got to find some policy remedies, and we got to continue to build this movement, tell our stories, make the case, change hearts, change minds, and just keep going.
Jess, I wonder if I could ask you what your thoughts were yesterday. And in particular, I'm thinking about Senator Dibble mentioning the 8-1 decision and what your thoughts are about, two of the three democratically appointed justices, ones that I would never have thought would have been like, yeah, torture for kids is definitely First Amendment protected. What are your thoughts on that? How do you think they arrived there?
That's a great question. And I was really grappling with that yesterday, trying to figure out what's their angle, what's their thought. I do think there's the concern of, look, we know major medical associations effectively call this torture, right? Like, we know that. But what we're seeing now when we litigate medical care related issues, like we're challenging North Dakota's gender affirming care ban, and what we challenge abortion bans, right? Like what we see is this kind of, okay, well, every major medical association in the country says this, but here's this new fringe, like newly created fringe medical association created for the purposes of this litigation, and they say something else. So now
Mm,
all of a sudden there's a quote unquote debate. Because on
sure.
the one side you have like every major medical association on this country, and on the other side you have like a tiny brand new ideological association with a litigation agenda. And
Yeah.
so what you could end up with is like in one state, like Minnesota, right, would say let's ban conversion therapy. But you could go, let's say, to North Dakota or South Dakota, and their lawmakers say we're going to ban gender affirming therapy. And I wonder if the judges had that a bit on their mind of like, we're going to see the same split that we see with gender affirming medical care. Like, we're going to see that. We're going to see efforts to ban like therapy, like talk therapy, that sort of thing, psychotherapy. Um, and we need to be able to kind of stand on principled grounds because both sides are going to have medical associations, both sides are going to have science. The problem is, when you dig into the medical associations and when you dig into the science, it's like one side has real science, real data, real medical associations, and the other side has junk science, and they're being treated as equal. And that's a problem, right? And that's the problem here, which is where it's not just like speech, it's like conversion therapy has been discredited. Like it's been, you know, so, but that might have been on their minds of like we need to kind of stand on principle because we see where this is going. But I mean, this is just me guessing. I sometimes like read opinions and I have an inkling of what judges are thinking. Here, I'm not so confident. I'm not so confident I know their reasoning, and it's possible they just this is just their position on speech. Like we want to be able to have a principled um position on speech that we can also apply when trans kids are under attack, which they already are, right? But like if a talk therapy ban on gender affirming talk therapy
Hmm.
comes, we want to be able to have a principled position on it. And I think the principled position could be like one side has real science and one side doesn't, but
Yeah.
yeah.
It's kind of
Could.
like those, is climate change real? We talked to two scientists and a random guy down the street at a diner. Who knows, right? It's like it feels very much like that. Um, it's like maybe we just talked to the scientists. There are some really, really great questions coming in. And I'm actually going to start with uh, the free speech for therapists. So one of the questions was, how much does this ruling, which is about therapist rights for free speech, have broader implications? For example, if this person who's a therapist didn't believe that a client should be taking any psychotropic medications or use mindfulness practices that they were asking about because my religious beliefs were not aligned with those remedies, like how much would it impact
So
that?
that's a super interesting question, and I think it actually relates a lot to the question above that, which I know folks can't see, but what I'll say is there are other restrictions. It does, what the question above is about like malpractice. And there are restrictions on the practice of medicine if you're licensed, right? Specifically if you're licensed. So you have unlicensed people providing services. Let's say like religious organizations might have a clergy member who's unlicensed but is providing therapy. So we're talking about licensed therapists. There's other sorts of things you could do. There's other restrictions that are in place, right? Like if you are my therapist and you harm me, like you do something that's been discredited, there's no science behind it, and it causes me harm, I can sue you for malpractice. I could file a licensure complaint, right? There's other mechanisms in place that limit what therapists can and can't do, and there's other ways to get remedies, but it's like at that point the harm's been done, right? Like the
Mm.
point of these laws is to prevent the harm in the first place. But there are going to be limits on what a therapist can do. Like if someone has a diagnosed medical condition and what's indicated for that condition is a psychotropic medication, and you say like no, don't take that, and the person dies, like there will be consequences for that, but those are like more about medical malpractice, licensure, wrongful death, like those kinds of harms. But at that point the person is already harmed. um so
And Scott, go ahead. I was actually going to say it. I think one of the bills that you have that I think is meant as a response to this also involves some of the remedies after the fact. You want to talk about that?
Yeah, first I wanted to mention that Justice Ketanji Brown Jackson uh, did uh, uh, dissent and wrote a very, very strong 35-page dissent. It's one of the things she said. She's very, very worried about the implications of this ruling for future cases on treatment. And, it kind of opens the door for the focus to be on the provider and not on the patient or the client. And in fact, if a provider can bring in their fervently held, faith-based or conscience-based beliefs, and then provides that as a rationale or a justification for delivering a treatment that does active harm to that person. This opens up the door for that kind of legal reasoning. And so that's upsetting to hear about. However, to the point that Jess just made, uh, we have introduced a bill. You're a co-author. Thank you, Senator Maye Quade, that would strengthen specifically for the purposes of conversion therapy, the ability for someone who has received conversion therapy and then can subsequently show harm to have standing to pursue a civil remedy, and to sue that person and to sue their provider, whoever else is in the chain, if you will, of responsibility for delivering that harmful treatment to that person. So, hopefully we'll be able to get that bill dislodged and heard and moving yet even this year. I haven't yet engaged with my leadership. We're past what we call deadlines, so it would have to be a late bill. So it'd be an extraordinary effort. So I want to manage expectations, but we'll try to get this bill moving. That would give individuals standing for civil remedies for harm that's caused by conversion therapy, which hopefully then would send a signal to the profession that they better think twice before they deliver what is effectively torture and harm to young people and vulnerable adults. Now, again, managing expectations, it occurs to me the House is evenly split between Republicans and Democrats. And even though the conversion therapy ban was passed on a bipartisan basis, I would venture to say that the Republican Party has moved significantly backwards, more retrograde on issues of importance to LGBTQ people in our lives and families. So I wouldn't necessarily hold my breath that the Republican Speaker of the House would release a bill like this and allow it to be debated on the floor of the House.
You can always hope. There's like this set of questions in here, and someone put into the chat what the bill number is. It's Senate File 4706. I don't know the House number, but I popped the bill into the chat so people can see that. Jess, there's a few questions, and it's like where I went to yesterday right away, and I was like, oh, okay, so do abortion providers have the right not to be told by the state what they have to say in a script? There's another question here, like, can we take a page of the anti-abortion playbook and consider bills that mandate conversion therapists to provide specific information before providing care? And so just, I think your response to me was like, that's not what this ruling does, but maybe talk a little bit more about it because I felt so sure, like, if we're going to do this, then let's go.
Well, that was Justice Jackson, what Scott or Senator Dibble mentioned earlier in terms of Justice Jackson's dissent, like that was kind of her point of like, if you take a look through the history of what we said is like a free speech violation and what isn't in the context of medical care, there does seem to be like an ideological line here. Like if you look at the mandated scripts for abortion, we seem a little more okay with that. I think it's really hard to say. The court tried to walk a line that to me doesn't work, but to them, I assume does, where they say like this isn't the state can force doctors to provide like non-controversial informed consent that everyone just agrees is true, right? Like if let's say there's a medication that carries certain side effects, like you could say a doctor has to warn the patient about that side effects because everyone agrees that's a side effect. The problem is like with the abortion scripts, like a lot of them are just in the words of the judge who heard our abortion case, a lot of them are just baloney. right? It's just made up stuff that's not true. And so it's very controversial. It's very ideological. I think it's really hard to read the court's opinion here and come up with like, yeah, so now they're going to strike down these abortion scripts too, because this court always leaves wiggle room for like to follow the ideological lines that they want to follow rather than to follow principled reasoning. And I saw them attempt to put that wiggle room into this opinion. So I would be surprised if an abortion script got in front of them and they struck it down and said like, well, what we said in Chiles v. Salazar, we meant it. I would be
Yeah.
surprised, but like, a good faith reading of child, like, yeah, like a good faith reading of this opinion would lead me to the conclusion that these baloney abortion scripts should be struck down as a free speech issue. Unfortunately, we don't really live in a world where I can like read Supreme Court opinions in good faith. So,
Well, that, and I think it's important to note too that like this court arrives at its answer and then works backwards to the reasoning to because they know what they want the answer to be. And you see that in everything from Skirmetti, which is allowing Tennessee to ban gender affirming care, and ignoring the parents who work with medical professionals to access like appropriate care. But then you have your Mahmoud case where they're like, no, parents have a right to like know everything that their kid is doing in school and approve of every like piece of books that are read, right? And so it's like over and over again, they twist themselves in knots to say, yes, parents' rights if you hate LGBTQ people, no parents' rights if you have a queer kid, right? Or a trans kid. And so I think that is maybe part of the answer too, is that like in a reasoned world, yes, we'd be able to look at this and say, okay, well then there is free speech rights for providers of whatever kind, but that will never apply to the ones that they don't like.
We have an expression for
So
that. It's called the law.
yes,
The laws are for thee and not for me. Uh,
yes,
like,
yes.
like the decision to allow uh, a football coach to basically coerce
Yep.
football players to come pray with him at the 50-yard line after a game. Now, if that was, a Jewish practitioner or a Muslim, there would be no such ruling and no such finding. And in fact, if that were to happen in some small town, you bet that there would be a move against that. And I'm sure this court would find in favor of prohibiting that form of religious expression and coercion into religious practice by teenagers, by a dominant adult. I wanted to, before it slips away, I did have another idea. Maybe I can workshop it a little bit with Jess in real time here in front of everyone. So the Kagan-Sotomayor decision was written separately from the Gorsuch decision. And in it, they tried to send a little signal that, if in fact the language of the statute regulating conversion therapy were uh, um, perspective neutral, uh, then maybe it would pass their test of free speech. So the thought that I had today and started noodling around with Senate counsel on some language in amending our statute to make it clear that it is outcome neutral, perspective neutral. However, the provider in the Colorado case talked a lot about how she only wanted to provide the kind of therapy that her clients brought to her, an independent expressed goal of theirs, and she wasn't free to treat them in that way. So so I thought, fine, let's actually make the goal and the intent of what those clients are bringing to their therapist truly independent and free from coercion and influence, whether by the therapist inside the therapy room or by anyone else outside of the therapy room. In other words, let's make sure that the therapy that we're providing is not that person is actually bringing themselves with the full agency of themselves to that therapy and that therapist, free from coercion and influence by anyone, whether that's a parent or a minister or anyone. And only then is there an actual legitimate, absolutely content-free, passing the uh, Kagan-Sotomayor test. but making sure that the person who's showing up for counseling and therapy aren't being forced into it by someone else's coercive agenda. So just testing some ideas, and maybe we can salvage, and that would be their professional duty and responsibility. They have affirmative responsibility to make sure that that person is showing up with agency and autonomy. And if they can't actually ascertain that, then they're prohibited from providing conversion therapy under those circumstances in that setting.
I think I think there's two th I love the creativity. I'm always here for it. The two things I can think of is one, Kagan, Sotomayor, and Jackson wouldn't still you still wouldn't get to the majority. So like you'd still kind of, you might peel them off. The other thing I'm thinking is like it would probably have to apply across the board. And it's a hard law to write. That's the thing with their opinion. We call it a concurring opinion when two justices agreed with the majority but write their own opinion, is I couldn't quite see what they were getting at when they said like if this were content neutral, we would allow it. Like it wasn't clear to me what they were saying. Like maybe a law that says like you cannot provide any therapy that's been discredited by every major medical association, that might be content neutral. Like maybe, but I'm with you in that like I think there's wiggle room in what they said there, but I'm not sure what it is. Like
Actually,
I read it, I caught the same thing you did, and I think you're on the right track. I just could not figure out what they were trying to say is the wiggle room. So
I'm not necessarily trying to uh, win a Supreme Court case.
sure,
What
I
I'm
should fair.
is
Yeah,
it
Well,
if
potentially, if it is your law that goes to Supreme Court. So
that's
I
fair.
think it actually brings there's two separate questions that are really similar. That is about, one was like, can this therapist in Colorado still be reported and possibly like lose their license because, how is she able to continue to practice? And then the second one is, can you confirm that therapists can still lose their license given how harmful conversion therapy is? Like there's a difference between legality and ethics. And, this kind of goes to there are ethics and there are regulations on professions that aren't necessarily about the law. And so there's questions around that.
I know there's therapists, psychologists, like I know there's folks who fall in that category on this call. So I would say to them, like, this is not legal, but like talk to a lawyer who's focused on regulatory compliance. But regulations like I'm not familiar with every single like all the regulations in all the states, right? But if you're a licensed physician, let's say in Minnesota, there's all sorts of regulations you have to follow. And you could lose your license. Like it would be maybe you can't lose your license because you provided this conversion therapy, but you could lose your license if you provide a therapy that's harmful, discredited, contrary to the standards of care, like not the accepted practice, not the accepted treatment for a specific diagnosis. Like if all of those things are true, then that's the reason you're losing your license, not because conversion therapy versus like affirmation therapy. It's because it's like, providing like high quality therapy versus providing nonsense. Like there are a lot of regulations in place to avoid like shams, gimmicks like snake oil, right? Like those laws would apply here. Those are content neutral laws, meaning they just apply across the board. If a medical intervention has been discredited and you're practicing not within the standards of care, that's a problem, right? No matter what it is you're practicing. And arguably gender affirming or arguably like conversion therapy would fall in that category. And if someone reports you, the licensing board would have to figure it out what to do. What they should not do is say like I'm discrediting you because I discredit anyone who provides conversion therapy. What they should do is say this is contrary to the standards of care, this is negligent, this is harmful, like the same reasons you would do it if someone violated any other standard of care, right? Like you leave like a clamp in someone after surgery, right? Like that's a problem, right? Like there's certain ways you're supposed to practice. You didn't put the guardrails in place. So it's then that's content neutral. That's just like on the same, any therapist could lose their license on the same grounds. It's just, conversion therapy is one of those things that you just should know you shouldn't do. And if you do, it's negligent. Um, so
And maybe this gets to the question that Ketanji Justice Brown Jackson brought up, which is, is there a difference? Well, maybe what does this ruling mean in the government regulation of different professions, and what does it or does not mean in professions that regulate themselves?
Like non-licensed?
Or no, I mean, if you're licensing, maybe you're licensed through the state, but there's professions where their licensing board sets up the standards and sets up the thing, and it's just through the state that they
Oh no, Erin, are you okay?
are. Yeah, I'm having a little bit of an allergy attack.
Yeah. Scott, should we try to answer so Erin doesn't have to talk right now?
Well, yeah, so we do have so licensure is a function of law. However, the enforcement mechanisms flow through not a state agency per se, but a licensing board, and that board is typically made up of other professionals, and so they self-police and self-enforce through the licensure standards and whether or not that license remains in good standing or not. They kind of are the ones who make that determination. Now, of course, a license holder always has the right to remedy through the courts if they disagree with the determination of the licensing board. But they they often don't prevail because these licensing boards do a great deal of due diligence. So I would. It's a great question because this was often kind of the refuge of scoundrels as we were trying to get the bill passed in prior years, prior to the year that we finally succeeded, which was, oh, just leave it up to the licensing boards to police the profession. The problem was in this area, they were hiding in the weeds. They just did not want to get into it. They didn't want to offend or make waves. I mean, repeatedly we would engage with the licensing boards and say, we would really love for you to move on this. And we have lots and lots of documentary evidence of licensed health, mental health professionals of a variety of sorts taking money and telling clients that being LGBTQ was disordered and problematic, the source of their problems, and they could change and they wouldn't move on it. So, hope springs eternal, and the
Yeah.
world has moved on, and hopefully, part of it is that all of you professionals out there, um, get on those boards,
Yeah.
step up and be a part of those conversations and be a part of those processes, because it's a lot of folks who just don't like to roil the waters and get into these really hot button controversial issues.
I'm looking at the questions to make sure that I didn't miss anything. And I think, Jess, there was a question that was kind of like going down this, what does this mean for different professions? The confidentiality example felt very salient, and that this decision could open the door for other important regulations to be challenged. And there's a VAWA program or VAWA funds program in here that's mentioned. Do you want to say, is there anything maybe in reading the dissent or anything you've read since then that would give you like, oh, here's maybe some can of worms that have been opened?
Um, the the best I can do with this ruling really is the court was they claimed to be fixated on is this content neutral or not. So they claimed that the issue here is that it specifically does not allow conversion therapy, but it would allow gender affirmation as though these are two, we know these are not equivalent, right? Like we know like one is supported by science and one is uh, countered by science. And so I don't mean to suggest those are the same, but just in terms of the court's opinion, it did really seem focused on this claim that the law was not content neutral. And so I would say like a law that says I can't disclose confidential client communications would be a content neutral law, right? Like no matter what it is the client tells me, no matter who the client is, I can't do that without their permission. And so I think the question then would be, does the court mean what they say when they say like, this is our issue here is it's not content neutral, or are they trying to go further? But no, I would say like I wouldn't look at a law that impacts someone's a licensed professional speech and say like, well, that law is now invalid because the court at least like on its face claimed what it was doing was taking issue with the fact that it was not content neutral. So the other, other types of regulations on professional speech might still stand, but they might also have other types of challenges you can bring against them. But this opinion may not really impact things that are content neutral that just apply to everyone, no matter the circumstances.
Mhm. Um,
I wanted to mention another couple of
yeah, go
things
ahead, Scott.
before they slip. One is we have two other components of the law that we passed when we passed it. One was that it is tantamount to consumer fraud to advertise the availability of this therapy as efficacious. Um, I don't know how this ruling would affect that, but um, we still have that in place. So you can't go out and hang out your shingle, change your sexual orientation, change your gender identity here. We'll get you all fixed up and send you on your merry way, because that is consumer fraud under Minnesota law. The other is we cannot use taxpayer dollars through our public health programs to pay for conversion therapy, conversion torture. So that stands too. And in fact, we do have a bill, Senator Maye Quade, you're a co-author as well. Thank you very much. That would extend that prohibition on paying even to private insurance. Because effectively, when you think about it, insurance is about all of us together paying in, and then we draw from that pool when we need it. And so, effectively, it's similar to using our tax money to pay for something that's harming people. It's using our premium dollars to pay for something that's harming people. And so, that bill is still rostered and hasn't yet been heard in committee, but hopefully, we'll get that moving too.
That's great. Well, we still have some questions rolling in, so I want to make sure we can get to all of these as well. Um, Jess, there is a question about what can we as attorneys, and this is like a royal we, not we at Gender Justice necessarily, do to prepare for potential challenges to Minnesota's ban?
Oh, that's a
And
great
I
question.
would extend it to North Dakota's as well. Yeah.
And North Dakota, yeah. So one interesting thing about the ruling is it there's different levels of scrutiny that a court gives a law. So it might like basically rubber stamp a law, right? Like Senator Dibble, Senator Maye Quade, they decide they hate red bowling balls. They're gonna ban them. Like they just don't want to see them. So they pass the like anti-red bowling ball bill. A court would look at that and say, like, is this rational? Like, do they have some reason they did this? And if you do, which I don't know what that reason would be, right? But let's say you came up with a reason why, they would basically rubber stamp it. They'd be like, oh, they have a rational reason for doing this. It's fine. That's good enough. But then there's like bills that implicate like really important things, right? Or they impact people, right? There's bills that might be racist. There's bills that might impact your life and your health and your safety. And we would hope courts look at those more carefully. When a law implicates like really important constitutional rights, like First Amendment rights, courts typically apply what's called strict scrutiny, right? Like they look at that law really closely and are very skeptical of it. And arguably, like that's really what happened here. Like the court just said, like the court, to the lower courts that, before the appeal went up, like you should have looked at this law more carefully. They didn't necessarily say like and find that it's illegal, right? Like there's things you can then do to say like, okay, well, court, look at this law really carefully. It is like we have a compelling interest. There's a really good reason why we passed it. And this law is as narrow as it could possibly be to meet those interests, right? Like there's legal arguments still to be made here that even if the law implicates First Amendment rights, it should maybe still withstand um, judicial review. And that's kind of interesting. Like a lot of people, I don't know if the case is going to continue from here, but technically it can. And I think like if Minnesota's law gets challenged, we can still try to raise those issues. The problem is it will end up in front of this very same US Supreme Court. So like what will come of it? I don't see a way you could avoid, like, some cases don't make it over to the US Supreme Court. They stay in state court and never leave. That case would probably make it to the US Supreme Court because there'd be federal issues. So I don't know how the outcome would be different, but I think it could be worth fighting anyway and saying like, okay, this law is really important. We have a compelling interest. Here's why we did it. And lawyers can file amicus briefs and file briefs in support of the state's position. So there's still stuff to be done. There's still arguments to be made. It's more like at the end of the day, this is going to end up in the same place, and we know how those judges feel. But you could do a lot of like public education and advocacy along the way.
And I think that kind of answers the question a little bit about, is the content neutral argument the best one to use when we're talking about free speech and defense of conversion therapy? So I think that's helpful. Let's see, where did this one go? There was one other question that I was seeing here. There was a statement about most licensing boards don't go and find out practitioners who are violating standards of care. They review cases when they're brought by people who filed complaints. And so not that they're shying away from hot button issues, but they're just rarely getting complaints about this. And so
I would push back on that.
Okay.
I would push back on that because we've had situations where I have had a case involving a client where this case is public. Like we talked all about client confidentiality, and now I'm like, my client. No, but this was public information. It was part of a public case, and we had our client's permission. A pharmacist refused to dispense emergency contraception to her, even though she had a valid prescription. And she did call the pharmacy board and got a very strange answer that turned out to be incorrect because we won that case in front of the Court of Appeals. But when she called the board, they kind of pointed her to this guidance that had been written like 20 years ago. Like I actually don't I do think that the boards I agree that a complaint has to initiate the process of them looking into it. But I also agree that even with a complaint, they do sometimes shy away from political controversy. Like if they could just resolve it quietly, because it never turned into the formal complaint that it should have.
Mhm.
That's how she ended up with us.
Well, I think that the last few questions here, and I saved them for the end for you, Scott, because there was a question about the status of bills introduced in the legislature banning gender affirming care for minors. There's a trans sports ban or a ban on trans people playing sports, particularly K through 12 students. So if you wanted to just give a little update on where the bad bills are, it sounds like.
So, that I can't really talk about the house. It's another planet. And so it's hard for me to keep track of what exactly is going on over there. But suffice it to say that even with the 34 split in the House, and the fact that we have a one vote majority in the Senate, um, I can just say that I couldn't be more proud of my DFL counterparts, my colleagues across the board. We are a big tent. We mix it up on a lot of stuff, which is great. That's the way it should be. But in terms of standing up with and for and by LGBTQ people, we have a lot of really rock solid allies in the Senate DFL caucus, the House DFL caucus. Not a one of those is going to make it past the post in either chamber. They'll be blocked on a tie vote in the House, and they're not even being brought up for consideration in the Senate because we have one vote majority and we have the ability to not hear those bills in committee. There may be attempts to pull them out of the committee and onto the floor of the Senate, and I can tell you those efforts will fail as well. And we have a very, very strong and solid governor who speaks out regularly on behalf of our community, as well as our lieutenant governor.
Attorney General.
Attorney General is amazing and has brought many lawsuits on our behalf very successfully against the federal government and other bad actors. But This is an election year. Having a tie vote in the House is unacceptable. Gender justice is, by the way, nonpartisan, et cetera.
Agree.
So so I'm only speaking representing myself, not representing the views of a nonpartisan nonprofit. But this is an election year, and this actually doesn't even have to be a partisan pitch. Take a really close look at who's standing up and supporting and the issues and the values that you support, and make sure that the outcome this November is such that we have a legislature that's more well positioned to advance what's important to us and our families.
Yes, and I will say, there's a senator that we serve with who's the chief author of one of the sports bans and posted about it, I think back in February, and there were hundreds of comments of like, "Are you kidding me? This is what you're focusing on right now? Like, look how high the price of gas is and food is, and we had our neighbors being kidnapped, and we have had school shootings, and like." In the grand scheme of like leave trans kids alone and like maybe let's solve some real problems, right? And so even the tide within community, I think is really changing. And I think there's some people who are realizing that the wool's been really pulled over their eyes, meant to distract them from things that aren't harmful and aren't anybody else's concern. Like we've had trans inclusion in sports for more than a decade in Minnesota. And we have the highest participation rate in girls' sports as a result of that. And so I'd like to keep that. And I'd also like to actually focus on supporting kids and not harming them, which is what we're doing, right? And that is what we will continue to do. So I'll, those are my closing thoughts in that I'm so glad we were able to come here and talk through this together and just realize that, we know what the Supreme Court wants to do. They will find their ways to the decisions that they want to make. So maybe even the legal reasoning isn't that important because they'll abandon this legal reasoning as soon as we try to use it for something that we support and they don't. But what the reality is that, Minnesota's conversion therapy ban stands. Today. It has not been overturned. North Dakota's social work ethics guidelines prohibiting conversion therapy stand. Those have not gone away. And that is true in all the other states, all the 25 other states in Puerto Rico and DC as well. So even though the attacks continue, we still stand strong here in Minnesota and in North Dakota. Those are my closing remarks. I'm going to come to you first, Jess, and then I'm going to come to you, Scott. What do you want to leave folks with?
Just that, we keep fighting on these issues. Like I don't want people to walk away feeling like anything's done. Like we litigate cases on hard issues that keep coming back again and again, like trans inclusion in sports, gender affirming medical care for adolescents, like all of these issues, sometimes the public discourse can just really weigh you down. It's so hard. The laws that get passed, all of that stuff is so hard. So I just want folks to know, like, we are still litigating these issues. They're still live. We're often doing well when we litigate those issues. There's a lot of people who support trans rights, support trans youth, support gay and queer youth. And so just know, like, a lot of people are we're in a really dark time, but a lot of people are fighting back. Not just the people on this call, but just tons of people are here for you. So
And if you want to sign up to receive alerts for our SCOTUS chats as decisions come out, it'll be decision season come this spring. There's lots of decisions left. The link is in the chat. Please do sign up, and you can always donate to Gender Justice and support us. Scott, I'm coming to you for your final thoughts.
Well, you both did so well. I don't have a lot to add, just maybe a variation on a theme, which is, this is a movement that's built on just people showing up every single day and being the heroes of their own lives. That is not unique to any movement for freedom and equality. And just keep doing it. And it is a really really hard time that we're living in. As hard as any time I've lived in my life. And when we started down this path with Donald Trump and others, I thought, well, I survived Ronald Reagan. I can. No, I will. It is worse maybe than even the Reagan era. And of course, we stand on the shoulders of just many, many, many people who, lived in the days of the Lavender Scare. This is a movement built on a lot of courage and people just continuing to show up. and just continuing to hold on to that belief and the promise of freedom and democracy. Just keep on doing that. But also, this is also a movement built on a lot of love and a lot of humor and a lot of creativity and art and music and poetry. Just keep doing all of that too. And we will prevail. We will.
Tell
Don't
us the
forget, it is
slogan.
an election year. That is important. And this is the most important election of our lives. I know we keep saying that, but this is democracy is at stake. We are going to win this November, but elections do not win themselves. So do all the things. You talk to your friends, neighbors, support candidates, door knock, give money, do all those things.
And so we do have a trans equity training coming up, and we'll pop the link for that as well. Scott, there was a slogan. I think you said it was back in the 80s. It was like in the morning, will you tell us what that is, and we'll end it there.
Uh, yeah. So this was a slogan that ACT UP used. I have to think about it for a minute. So I got my start in an organization known as ACT UP. A lot of you know who that is, but who that was, but a lot of you won't. And that stood for the AIDS Coalition to Unleash Power. And it went something like, in the morning, we buried our friends. In the middle of the day, we fought like hell in the streets, and at night we danced our asses off. Something like that. It was something like that. So, this like it's all the things, it's the reality of our lives, can be really grinding and really tragic and really serious. But we fight like hell and we don't give up and we live and we love and we celebrate and we build community.
Yes. And Alex I think, put a little bit of it too in the chat. During the darkest days of the AIDS crisis, we buried our friends in the morning. We protested in the afternoon and we danced all night. And it was the dance that kept us in the fight because it was the dance we were fighting for. That's beautiful. Thank you. Thank you so much for your guidance and your wisdom. Thank you all so much for being here. We will be back with another SCOTUS chat. I'm sure you'll see us many times throughout the spring and the summer for maybe some celebration, maybe some grieving, but definitely some grounding as we move forward together. Thanks, everyone.